Good morning, everyone. I make the time 9 o'clock a.m. It's time for our special meeting this morning. I'd like to welcome council and thank you for coming in to attend. Councillor Height is on personal business today, so he will not be in attendance. I'll go right to the agenda. First, is there a disclosure of pecuniary interest to declare at this time? Hearing none, I'll go to item 2, which is a discussion item, procedural requirements, and this is concerning the May 23rd closed session relating to the OMB hearing. As you can tell on your agenda, this meeting this morning was called and council was notified to deal with a acquisition or disposition of land in Ward 5, that is item 3A. Also, we have been asked if we can deal with item 3B, which is direction to our solicitor respecting an OMB hearing matter. I am going to give you my opinion and my ruling on adding item 3B to this agenda, and of course, after I give my opinion, I will certainly ask staff for theirs, and then I will open it to council to discuss whether or not they want to deal with 3B this morning under the special meeting. My personal feeling is, as chair, that item 3B is not appropriate to be on this agenda. It would be appropriate on another agenda, but not on this agenda. Special meetings are called because of time-sensitive matters, and this meeting was called to deal with item 3A, and this 3B would be an add-on, and I don't believe that is appropriate under this format. If council decides not to agree with my ruling that 3B should not be dealt with this morning, they can overrule the chair. And that's appropriate, and I get that. This matter, and I'm speaking of 3B, which is an OMB hearing matter, was fully dealt with this year by this council and ruled on by this council, and I have faith that it's now in the OMB hands and they will deal with it. There's really no public notice to many, many people, citizens in our county, that have quite an interest in Hastings Drive. And many of those people that have had continued interest in Hastings Drive, as you can tell, are not here. There are some, and we welcome them, but there are many that are not aware that council is considering discussing this. And I also want to say, and it's painful for me to say this, but I also want to say that we have had concerns raised to the ombudsman of this council's dealing with in-camera closed sessions. Not so much what's been said in those sessions, but how we have dealt with going in and out of those sessions. And we've already had, as you know, one investigation into that. So you know my ruling, and I will turn it and ask Mr. Clerk for your opinion, Mr. County Manager for yours, and then certainly the decision will be up to the majority of this council, not to myself.
Through you, Mr. Mayor, I think that there are a couple of interesting aspects here. Usually special meetings are for just the item that they're called. This meeting isn't being televised because we didn't have time to give notice to Eastlink, so it's only being web streamed. So there are a significant amount of people in the community who would be interested in this discussion who won't be able to hear it or understand what's going on here at council. That's the one aspect about adding stuff to the special meeting in this fashion. Previous to the amendments of the overall procedural bylaw done in 2015, this wouldn't have been a possibility because the previous version of the procedural bylaw did limit special meetings of council to only one item. The problem was that there were occasions where we had multiple urgent issues to deal with, and so this has kind of crept into that broader responsibility to bring forward more than one issue that's very time sensitive has created a situation where an item could be. And procedurally, the closed session, I don't think would be a valid use to go in to discuss in closed session this today. There is the other matter, I think, that we'll perhaps maybe deal with a bit after, of whether or not reconsideration should be required. In this case, I've given my assessment that reconsideration is something that should be required by council, and so adding it on this way in some manners might remove the requirement for two-thirds support of council for that. So that's a bit problematic because there's only one way to bring forward reconsideration, and that's through the notice of motion process and the two-thirds requirement. So through adding it on this way, we're switching it to a simple majority. So there are some deeper procedural issues that council may want to consider, and we're here just to offer advice, and obviously whatever position council takes is acceptable. Thank you.
Mr. County Manager, do you wish to add anything?
I'm in full, the clerk and I have discussed this through, and I've got to say, we are in lockstep in our view of how this should work procedurally, which isn't to say we aren't here to attempt to throw a monkey wrench into how it is council wants to address in this issue. Which is to say, on November 21st, we are scheduled to go to discuss the in-camera matter with Mr. Tice, who's scheduled to be here on November the 21st. There is plenty of public notice. That is our regular process. We'll have an opportunity to have fulsome discussions in a closed session entirely properly. In the event, it might seem trivial or like we're picking on a procedural item. Really, we aren't, as far as guarding the integrity of the process and the capacity of others to challenge whatever decisions you ultimately make, you already have made, and whatever future decisions you might make. So the reconsideration is quite an important point, and there's nothing stopping a member of council from bringing a notice of motion for a future date, such as November 21st, if you actually want to go by way of reconsideration. But the manner in which although that wasn't the intent, the way this has got on the agenda today does sort of circumvent that normal two-thirds requirement, that normal notice of motion. So I'm not saying a member of this council couldn't provide notice of motion. You're perfectly capable of doing that today, and we'd still be able to hear this calendar year. But certainly, I think both Mr. Grosel and I view this as procedurally kind of muddy at best, if not outright incorrect, and hence our advice to you, if we may. Thank you.
Okay, just before I go to council, got to be honest with you, I haven't dealt with this specific situation in my experience. Mr. Clerk, just so that we proceed properly, the chair, myself's ruling this morning is that item 3B, I am ruling that it is out of order. It would seem to me, and you correct me, that if a member of council challenges my ruling, and they have the right to do that, and I will entertain that, then to challenge a ruling of the chair is not debatable. Would you just tell me how to proceed here with this so I don't get off track, please?
Through you, Mr. Mayor, the process to challenge a ruling of the chair is for a member to stand up and indicate that they do desire to challenge a ruling of the chair. And then we only accept questions of clarification around the challenge, and we vote immediately upon it. The outcome is a simple majority for a challenge to the chair, so that's kind of how we will proceed if there's a desire to keep that item on the agenda.
So just to be clear, if a member desires to challenge, they can do so. And And at that point, I'll only entertain questions of clarification, not debate, correct? Not debate, but clarification, no debate, and then a simple vote of council and majority will go. Okay, is there a member of council that wishes to challenge my ruling? Okay. Councilor Oliver, please.
Thank you very much, Mr. Mayor, and I preclude any comments by saying I guess I will accept some responsibility for even having this on our agenda this morning, and my desire was to determine how council could provide further direction to our solicitor at a time appropriate and prior to the OMB hearing, which happens, we know, in January, Mr. Mayor. So that was the background as to why I exchanged emails back and forth with Clerk Roselle and to why we're here. So may I ask, through yourself, Mr. Mayor, for some guidance from Mr. Baird or Mr. Cribbs regarding the timing of certain times for the OMB hearing?
Absolutely.
Okay.
Yes.
Thank you very much. At our request, Chris arranged, and I appreciated that fact, arranged for Mr. Tice to come and seek further direction, or at least have further discussion with council on the 21st of November in an in-camera. Great. That was going to be in advance of the OMB hearing, which happens in January. We were then informed that in terms of the sequence of things leading up to the OMB hearing date, that November the 21st itself has some significance, I thought, in terms of the disclosure of positions, et cetera, amongst the parties. So my question through you to Mr. Baird is, could we request, as the county, not necessarily a deferral on the date of the hearing, because I realize that kind of gets set in stone, but at least a deferral of when we would have to provide our formal position, if you like, or that November 21st milestone date in the OMB procedural. Because if we can ask for a delay, then dealing with this matter in camera on the 21st would be no problem, in that we could clarify what our position is, it could be communicated by our solicitor, and then the hearing can proceed on January the 8th.
Mr. Baird, please. Thank you.
Through the mayor, there is no correlation to that meeting date. This was purely the availability of Mr. Tice. So I can't really comment further. If council wishes to select another date and direct Mr. Tice to be in attendance, by all means, we will take that direction forward. But I have really nothing more to offer in terms of a key date relating to the procedural process, and perhaps Mr. Cribbs may want to add to that.
I take off my county manager hat and just revert back to being a staff lawyer. What I can tell you is that there is an OMB hearing in January of 2018. This council has given specific instructions to Mr. Tice on how to litigate said file. He is preparing for that OMB hearing in accordance with those instructions. Regardless of whether or not at a future point in time, I'm thinking November 21st, but this council wishes to change its instruction. And again, it's our take that requires a 2/3 majority, but whether that's a simple majority or a 2/3 majority, if regardless of whether or not changing the instruction, no lawyer in good conscience can do anything other than properly prepare for that hearing. So that involves a bunch of work. At this point in time, the witness lists have already been exchanged. So the county has already said who its witness will be, which happens to be one of our planning staff. That's the extent of the county's case. So what I'm trying to get at in a roundabout way is that really no action today would have a material impact upon what a lawyer in good standing with the Law Society could possibly, in this case, Mr. Tice is going to be obligated to continue to prep for that, which can involve it going many different ways. So there isn't any savings to be had by changing instruction or asking for deferral. There isn't any, some of the stuff's already done, and other stuff is work that has to be done regardless of whether our position is A, B, or C. So I'm not aware of any benefit as far as, to the municipality as far as financial savings or administrative efficiency or similar in asking for any sort of deferral or suggesting that something not go forward, because really, regardless of what the end outcome will be, we don't know what that is. Some prep time is needed, and he's doing that. So in that sense, I don't see any benefit.
Okay, thank you for that, Mr. Mayor, and thanks to staff. I think in that context, then, from my personal perspective, Mr. Mayor, I acknowledge what we've been told by staff in your own ruling, Mr. Mayor, that we don't need to deal with a matter this morning vis-a-vis these dates that are coming up. It is my position, myself, that council, when the time is determined to be correct, and that may be November the 21st, that council does have the legal authority and the right to provide specific direction to Mr. Tice leading up to the hearing, and that would then become the position that he would take forward to the hearing. Because as I've reviewed all of the motions that have been passed by council going back to the 12th of July 2016, it's not in any way clear to me that we have provided specific direction to Mr. Tice. And so that's why I'm very anxious for council to have an opportunity before the hearing takes place to provide further direction to Mr. Tice. But I'm prepared to wait, Mr. Mayor, myself at least, and deal with that on the 21st. Whether or not we need a reconsideration of a previous motion, I'm prepared to have that debate at that time.
Okay.
But I'm taking some assurance from what the county manager says, in that regardless of what we might do prior to November 21st, if we meet with Mr. Tice on that date in closed session, we will have the right, either by reconsideration or by simple direction, to give him our direction as to how he should handle himself at the hearing. And assuming that's sort of what Mr. Cribbs was saying, then I, for one, am prepared to let this matter not be dealt with this morning. We'll deal with it on the 21st, because I'm not personally inclined to challenge the chair.
Thank you. We're not going to debate. Is this clarification? Or if someone wishes to proceed with overruling my ruling, I'll entertain that, but not a debate. Councillor Black, clarification, please? Or overrule is fine.
Well, I don't want to debate it, and I just want to say that I agree with your ruling, staff's ruling, and appreciate the councillor not bringing this forward.
Anyone else wish to speak? We will proceed then this morning with the special meeting to deal with one item, 3A. I'm going to move on then. Moved by Councillor Wells and seconded by Councillor Brunton. The council move into closed session at 9:18 a.m. to discuss matters pursuant to Section 239C of the Municipal Act 2001 as amended, as the subject matters pertains to a proposed or pending acquisition or disposition of land by the municipality or local board. Any discussion on this motion? Those in favor? Carried. We will move into closed session. Thank you.